Good morning. It's Ryan Hoff, Legislative Director for the Association of Indiana Counties, presenting your strangely timed 2020 legislative update. Obviously, it's been a few weeks, but it seems like longer than that since the legislative session actually ended. Now that we're in the midst of a pandemic, the world's a much different place. But oddly enough, this year's legislative session was ending just at the time that everyone was coming to grips with closures and cancellation of basketball games. And it seems like a much different world than where we left on sine die of the legislative session. But the fact remains, these are new Indiana laws that we would like to share with you. And I'll try not to go into too much discussion of COVID-19 because all of this took place before anyone understood where we were going to end up only a few short weeks later. But this year was a short session, meaning they did not write the 2-year state budget. Going into this fall's elections, we understood there were always going to be a lot of retirements, and that certainly seemed to be the case. Multiple senators, multiple members of the Indiana House of Representatives have all announced their retirements. So you're going to see a much different legislature next year. And that continues a trend over the past couple of years where you have new legislators requiring more outreach, getting to know the legislators, educating them on our issues. Probably most notable is the fact that Speaker of the Indiana House, Representative Brian Bosma, announced his retirement going into this session. In the last week of the legislative session, the gavel formally transferred to Representative Todd Houston of Fishers, who becomes the new Speaker of the Indiana House. That will be especially important going into next year's budget session. Of course, this year is fall elections. You have all 100 members of the Indiana House up for election and half of the 50 members of the Indiana Senate. So you'll have 125 elections for legislators this fall. And even though it won't take place until after the census is complete, everyone has one eye kind of on the redistricting that will happen post-census. Going into this year's legislative session, there were multiple issues that were thought to be the hot topics for this session. That included the Teacher Red for Ed campaign that saw, if you remember way back to last fall, saw thousands of teachers rally on the State House lawn in the State House on Organization Day, interested in multiple different things related to education, pay, testing, myriad of things. Also, healthcare costs and hospital profits were receiving a lot of focus. Also, distracted driving. The governor was pushing for a distracted driving law, meaning that you can't have a cell phone in your hand or while you're driving. Also, discussion of electric utility generation facilities was a hot topic, whether or not locals should continue to have a role in siting of electric generation facilities. AIC, on your behalf, tracked over 250 of the over 900 bills that were filed this year in the Indiana General Assembly. That doesn't include, of course, the hundreds of amendments filed, in addition to more hundreds of good ideas that legislators and others have. So it certainly keeps you on your toes, especially in a short session. All the action is time compressed, so it's a pretty fast-paced environment. But getting into the legislation as passed. Dealing first with state and local finance. House Bill 1113 was this year's DLGF kind of cleanup bill, if you will. A lot of different issues dealing with local government, county finances in particular. A lot of small tweaks, a lot of cleanup. I'll just go through kind of the high level issues, of course. We won't have time to go in detail into every issue. However, some interesting new legislation to be aware of as county officials. First, what has always been known as the assessed value growth quotient is now changed to be called the max levy growth quotient to more closely mirror the actual use of that information. This legislation also redefines yard improvements for purposes of golf course assessment, amends the requirement on owners to provide income data to the assessors, beefs that up, also fixes the business personal property Property Tax Board of Appeals final determination deadline. In code for a handful of years, there had been a loophole that allowed a taxpayer that if they drug out their business personal appeal, they could drag it out long enough to the point where the PTBO was unable to issue a final determination before the statutory deadline, thus ensuring that the taxpayer would always win. This legislation cleans up that loophole and ensures that the appeal is based on merit, not on a timing loophole. The bill requires the tax bill sent out to include information on where the taxpayer can locate a subsequent year's assessment information. It doesn't have to include the actual information of what the next year's assessment is. However, it will have to say where they can find it, whether that's calling the assessor's office, if it's posted on the county's website, wherever the taxpayer can find it. The bill requires that any township budget increase or additional appropriation must be adopted by the county fiscal body if the majority of the township board are precluded from voting due to being immediate family member of the trustee. Again, that is a must be adopted by the county fiscal body. Currently, there is some advisory, non-binding review by the county fiscal body, but this would be a binding review. House Enrolled Act 1113 also eliminates unnecessary information from the sales disclosure form. DLGF and assessors and other interested groups worked on this over the course of last summer. The bill extends repayment of appeal awards options for the county. The county has three options: a 5-year repayment or credit if the refund is over $500,000, 7 years if it's over $5 million, or 10 years if the repayment of after an appeal is over $10 million. Probably fairly rare that we'll get over a $10 million refund, but on some especially large properties, it is certainly possible. The bill extends a prohibition on delinquent tax sale purchasers from purchasing more property in tax sale, extends that to any other business entity in which the delinquent individual has a business interest. So they can't form new shell corporations to buy up tax sale property if they are delinquent in a different business entity. Also requires that a taxpayer remains qualified for property tax deductions if their AV rises above $200,000. That was a change from last year, but this extends it to cover any increase, including reassessment. So unless the increase is attributable to physical improvements on the property, just makes it a broader guideline for counties to be able to follow. Moving on to House Bill 1065, which include a change to lit board voting processes. This bill changes the voting procedures for a local income tax council. This is former COIT counties in which a single city controls the lit council. So that's Allen County, Monroe County, some other counties. Under current law, the fiscal body of the county, city, or town that is a member of the lit council casts its vote as a block in total for that unit. This bill amends that process in those applicable counties so that each vote of a fiscal body's individual members count toward the total lit council vote, not as a vote of that unit's fiscal body. The bill also voids action taken by a lit council between the new year and April 1st of 2020 to prevent a rush to adopt new rates before enactment of this legislation. Moving on to some what I term state government oversight. This is where the legislature gets involved in local decision making. Senate Bill 100 deals with non-conforming uses of structures, provides that the parcel owner shall be allowed to reconstruct, repair, or renovate a damaged or destroyed non-conforming structure if the square foot of that foundation is not increased. The background here was a lake home in, I believe it was Noble County, had some foundation damage. The county was telling them that to repair their foundation required a building permit, and because the structure was a non-conforming use, due to setbacks from the property line, they were not allowed to repair their home. This bill would continue to allow them to repair, reconstruct, or renovate a damaged or destroyed non-conforming structure as long as the size of the building is not increased, does not apply in historic districts or floodplains. House Bill 1414 deals with Indiana Utility Regulatory Commission oversight of electric generation facility closures, specifically closure of any generation facility that generates over 80 megawatts. The utility would have to notify the IURC of its pending closure. The IURC would hold public notice and public meeting on the closure. This bill was aimed at keeping coal plants open until a legislative task force could complete a 2-year study of electric generation and need in Indiana. Has the potential to impact counties that have coal generation facilities in terms of the schedule of their closure, and not only their closure, the pending loss of that property tax base, but it also has the potential to impact counties where wind and solar development may be ripe. That development may be slowed as a result of this legislation. Senate Bill 408 was the Department of Revenue cleanup bill. Of note for county in that large piece of legislation is that it requires counties to provide parcel level GIS data to the state in order to populate the new Department of Revenue computer system. This will help to make sure tax compliance is correct in terms of things like food and beverage taxes, but also will allow the Department of Revenue to collect income tax in a different way down to the parcel level, which is necessary if the legislature continues down the line of considering separating local government finances in terms of income taxes to allow counties their own rate and cities and towns their own rate, and you wouldn't have a combination of authority there. That was not part of this legislation, but has been a broad discussion topic for the past couple of years, and this is a small step in that direction so that the legislature may continue considering that concept. House Bill 1108 was a State Board of Accounts legislation, allows SBOA to issue subpoenas to force filing of certain reports, clarifies that a judge may remove a local official from office for failure to file audited reports, interference with an audit, or adoption of a system of accounting, and institutes a financial penalty of up to $500 a day for which the official can be personally liable as an alternative to removal from office. This followed a Supreme Court decision in Indiana where a city's clerk treasurer had not accounted for any spending, had not documented any financial information for basically the entirety of her term of office. And this legislation codifies a large part of what was in that Supreme Court decision. Senate Bill 216 deals with disclosure of information to an offender, updates the Access to Public Records Act so that personal information on a correctional, probation, community corrections, or law enforcement officer, judges, crime victims, or their family members may be withheld from disclosure when requested by a person in prison, county jail, detention facility, or community corrections program. Currently, under law, there is a prohibition against providing that information to offenders incarcerated in a penal institution, and this legislation would expand that concept to county jails, other detention facilities, or community corrections programs. On to government organization. Senate Bill 20 dealt with county plan commissions and requires that appointments, alternates, designees, or replacements on the plan commission must meet the same residency requirements as the initial member. House Bill 1182 deals with syringe exchanges, requiring a syringe exchange program to provide for testing of communicable diseases and provide services to the individual if they test positive, and also to establish a referral process for participants who need information regarding communicable diseases. House Bill 1047 deals with the Justice Reinvestment Advisory Council. This adds members of the evidence-based decision-making panel to the Justice Reinvestment Advisory Council. Those are big names for two different groups who have been studying the criminal justice system in Indiana and taking a look at the issues that have been the fallout from enactment of House Bill 1006 for the past handful of years that sent level 6 offenders back to the county. This legislation would include AIC representation to the state advisory panel, which conducts a state-level review of local corrections programs, jails, probation, and the processes used by the DOC and the Division of Mental Health and Addiction in awarding grants to counties that are part of the Justice Reinvestment Program. House Bill 1346 deals with jail overcrowding data. One of the missing links in criminal justice in Indiana has been a lack of real-time information on who is in jail, why they're in jail, and so forth. It requires the Indiana Criminal Justice Institute to receive data from sheriffs on jail population and jail statistics, and then it assigns the Justice Reinvestment Advisory Council to review that data and make recommendations on strategies for alleviating overcrowding and providing alternatives to incarceration. Tax sales and land issues. House Bill 1090 deals with cemeteries, allows but does not require counties to assume maintenance responsibility over cemeteries. There was testimony in the legislative process that there were counties out there who were interested in being able to take over what had been kind of forgotten cemeteries, to voluntarily take over the maintenance of those, except there was no provision allowing that in Indiana law. So this bill would, for the first time, allow the county to assume that maintenance responsibility if they choose to do so. House Bill 1370 authorizes counties to enter into agreements forming regional land banks. There's an area in southwest Indiana who was particularly interested in establishing a regional land bank. I think 5 counties were looking at going together to create a land bank. And for surveyors and commissioners, Senate Bill 229 deals with isolated wetland permits. In the last days of legislative session, this was one of the most hotly contested pieces of legislation, but it provides that a permit is not required from IDEM, Department of Environmental Management for some reconstruction or maintenance projects of regulated drains, as long as the work takes place within the current easement and the reconstruction does not substantially change the characteristics of the drain for which it was designed and constructed. Now, this only affects state regulated wetlands and permits, does not affect federal wetlands. Jurisdiction of federal government will still need to be determined and recognized where appropriate, but it does take IDEM out of the regulatory and permitting structure for these isolated wetlands and certain reconstruction projects. Now, with that, I will hand it over to Christine, who will go through some court and elections issues for you, and I will be back after her presentation.
Great, thank you, Ryan. My name is Christine Traina. I'm the Director of Planning and Government Affairs Associate here with the AIC. And I did promise a few clerks that I would include a picture of my son in his future voter t-shirt in this slide deck. Now, in honesty, this picture was taken last year. However, the shirt does still fit, and he will be wearing it proudly on June 2nd. So diving into election issues, House Enrolled Act 1147 allows a town or city with a population less than 3,500 the option to move the municipal election to an even numbered year. Again, this is simply an option, and it would give the option to about 18 small towns with mayors. I'd like to thank Fountain County Clerk Paula Copenhaver for suggesting this language and testifying at the State House. House Enrolled Act 1267 is language that Knox County Clerk David Shelton suggested and testified on at the State House as well. It allows the candidate 81 days to withdraw before the primary election instead of 85. Clerk Shelton had a situation where a candidate withdrew after the 85 day cutoff, and the county had the expense of that ballot, which wouldn't have been necessary if the withdrawal had come in earlier. So this gives people essentially the weekend to give it one last serious thought. Senate Enrolled Act 1288 was authored by Representative Mosley and gives county election boards the option to offer local candidates to file campaign finance reports electronically, just like the state does. Other than the three bills that I just reviewed, there were four other major election bills that worked their way through the process this session. Unfortunately, two of them died in the last days of session. Those were Senate Bill 178 and House Bill 1222. We'll revisit some of those issues again next session, and any of those issues that we weren't able to insert into these other two bills. Senate Enrolled Act 334 saw most of the language from Senate Bill 178 and some of the House Bill 1222 language added during conference committee. Senate Enrolled Act 334, it requires county boards of elections and registration to attend election security meetings hosted by the Indiana Election Division. It requires the Election Division to establish best practices for election officials to give instructions to voters on the voting process, including how to vote by straight party ticket and how that process works. It also requires language on the ballot or on the voting system to tell voters that straight party voting is not required. Then it makes changes to the voter list maintenance program and removes Indiana from the Kansas Crosscheck program and establishes the Indiana Data Enhancement Association, or IDEA, to administer the voter list maintenance. It sets parameters for when a county may rely on voter registration information from other entities in other states, and requires voter registration offices to determine if an individual authorized the cancellation of a previous voter registration when they registered to vote. It also requires county sheriffs to send a quarterly report of individuals in correctional facilities to the county voter registration office. If you attended our legislative conference in February, we talked a lot about Senate Enrolled Act 179. It requires counties to enter into an agreement with the Secretary of State to use a threat intelligence and enterprise security company called FireEye. The provision does have a sunset of January 1st, 2023, which is how long the funding is available. There are also provisions to protect the statewide voter registration system, including some standards that must be met to access SVRS, and also the requirement that any USB drives used to upload unofficial precinct election results, that they have malware protection on them. Senate Enrolled Act 179 also adds requirements to check an election equipment batteries and battery backups, and adds some clarity to the number of voting systems included in a public test. Voter verifiable paper audit trails, or VVPATs, those were a hot topic during last session, during the 2019 session, and Senate Enrolled Act 179 adds clarity to when they are to be printed and how they are to be used in a recount. There's also a provision to address some voter confusion and removes the active or inactive status of a voter from being displayed in the e-poll book. And then it does address how the Secretary of State will designate and administer risk-limiting audits. Moving on now to court issues, Senate Enrolled Act 47 deals with expungement issues. It defines protection order records and requires companies that provide background checks to treat them in the same manner that they do expunged convictions. It stipulates that if a court reduces a level 6 felony to a misdemeanor, that the 5-year waiting period for expungement begins on the date of the conviction and not when it was converted to a misdemeanor. It also allows law enforcement agencies to inquire about an expunged record, and if the person applies for a job, and they may refuse employment because of it. And then it specifies the procedure to expunge records of a collateral action that was entered in a different county than the county that issued the expungement order. Senate Enrolled Act 187 allows the Elkhart County Clerk and courts to expand to a site outside of the current courthouse. Senate Enrolled Act 256 is the annual Courts and Judicial Officers Bill. It specifies when requests will be taken for new courts and officers and what information is needed. Clark, Delaware, and Marshall counties were approved for new courts, and Gibson, Hamilton, and Jennings counties for new magistrates. Senate Enrolled Act 302 establishes a procedure for a court to determine if a defendant is indigent and allows the court to prorate fines, fees, and court costs based on the person's reasonable ability to pay. Senate Enrolled Act 424 expands the address confidentiality program to include victims of harassment, human trafficking, intimidation, and invasion of privacy. And with that, I'll turn it back over to Ryan for some final thoughts.
Of course, bills that actually passed only make up a fraction of the legislation that is filed every session. A large part of what AIC does on your behalf is preventing bad legislation from becoming law. In fact, that probably takes more time than getting something positive passed in the first place. So wanted to go over some of the bills that did not pass to discuss the type of ideas that the legislature sometimes has that we need to do a good job of educating how these issues would affect local government, county government. But again, these did not pass, although a lot of these bills we've seen before, and I feel like we'll see again. So feel free that when you're talking to your legislators, bring up some of these bills that didn't pass to make sure your local legislators understand the detrimental impact that they would have to your county. For example, Senate Bill 46 was, as drafted, was a stormwater fee exemption that would have exempted all governmental, nonprofit, and agricultural land from paying stormwater fees. Now, that would have been a massive fiscal hit to counties, taking all of these payers out of the system, potentially causing likely causing shortfalls in your drainage budget, possibly endangering any bonds that you have related to stormwater fees, and shifting all of the burden of those fees onto the remaining base of taxpayers, which likely would have been homeowners. So even though governmental, nonprofit, and ag land under this legislation would have been exempt, someone's still got to pay for the infrastructure that is being put in by county government, and largely homeowners who would have been left holding the bag. Again, did not pass, although it was heard in committee and was moving through the process at one point. House Bill 1309 was a verification of exempt pollution control personal property. In Indiana law, there is an exemption from business personal property for certain pollution control devices. This would have removed the requirement that IDEM verify to the county if that personal property is exempt. IDEM, through this legislation, was attempting to shift that responsibility onto the assessor directly. However, it's a little baffling as to why they think that the assessor is best placed to verify if a pollution control device is actually installed and properly working. Again, did not pass. Senate Bill 385 was a business personal tax exemption, which would have changed the valuation basis for purposes of the under $40,000 business personal exemption. Used to be known as the de minimis exemption. However, it's been expanded to the point where I'm not sure you can really call it de minimis anymore. So under Indiana law, if a business personal payer, if their entire business personal property has an acquisition cost of under $40,000, they're exempt from paying business personal tax. This would have changed that from the acquisition cost as the basis for determining whether they were under $40,000 to a depreciated value of under $40,000. That would have roughly tripled the fiscal impact to counties, and especially given that they just raised it from 20,000, the threshold from 20,000 to 40,000 last year. We felt it was especially harsh on local units to suffer loss of tax base again this year. This bill did pass through the Indiana Senate, however, did not receive a hearing in the Indiana House of Representatives. Senate Bill 148 originally dealt with zoning and manufactured homes, prohibiting a local ordinance from denying a structure solely because the structure is a manufactured home, or mandating size requirements for a manufactured home placed in a mobile home community. For at least 3/4 of session, that's all that bill contained. However, in the last week of consideration before conference committee started, it was amended to also include a complete preemption of any local ordinance that regulates the landlord-tenant relationship. That bill was vetoed by the governor, and in my current recollection, I think that's Governor Holcomb's first veto of legislation. But the bill was vetoed after session, after hearing opposition from housing advocates and local government. So again, did not become law, would be eligible for a veto override at some point. But the governor's veto message did indicate that, especially in light of COVID-19, it just didn't make sense to completely preempt local ordinances dealing with landlord-tenant relationships. Another bill that did not pass this session, though made quite a long way through the process, was Senate Bill 324, dealing with micro markets, which are essentially large vending machines that dispense fresh food. This bill would have prohibited a political subdivision from charging an installation fee for a micro market or a vending machine. Also would have limited the annual county Department of Health permit fee for a micro market to not exceed $60, and a permit fee for a vending machine could not exceed $8. Now, vending machines and micro markets are maybe considered somewhat somewhat a niche function or a niche review that county health departments do. However, this for the first time would have limited a local unit's ability to adopt a suitable fee that covers the administrative costs of providing those inspections, and certainly did not want to create a situation where this year it's micro markets, next year it's restaurants, the following year it's another industry, everyone looking to adopt a limit on the amount that they have to pay for their permits or inspections. And again, that bill did not pass with a lot of local health departments being actively involved in contacting their legislators in opposition. Looking ahead to next session. Now this, of course, it's always a little bit difficult to look into the crystal ball and see what may happen from one session to the next. The only thing that we can be sure about is that they're going to have to consider a state budget next year. Beyond that, anything that we may be talking about today that isn't related to COVID-19 response, who knows? Obviously, there will have to be some level of response in the state budget, not in the state budget. That will certainly take up a large amount of the legislature's focus. Beyond that, there are issues which may directly or indirectly relate to COVID-19, healthcare costs. Obviously, everything surrounding hospitals is different today than it was even 2 months ago. Teacher pay will obviously be an issue in the next budget. Rural broadband, now that everyone is working, well, I say everyone, a lot of people are now working remotely who didn't previously work remotely, and rural broadband being available to a large part of Indiana will continue to move up the list of priorities. Mental health facilities, the MVH 50% spend rule that has been a limiter and a bottleneck for local government finances, and local, as I mentioned before, local income tax authority, and considering whether or not each unit should have their own adoption and spending authority to no longer kind of commingle local funds. You have an adopting body having to adopt tax rates for other units. So again, looking into next session, it's all going to be a new world, and the issues that will be important to the legislature continue to evolve, and we will be here on behalf of Association of Indiana Counties to provide input into that process. If you have any questions about any of the legislative action that happened this session, or looking ahead to next session, or any other matter related to county government, please feel free to reach out to us. You see our contact information for David Bodorf, our executive director, myself, Christine, as well as our website. And certainly want to thank everyone for their involvement this past legislative session. Always encourage county officials to get involved in talking to your state level officials if you haven't been already. Again, thank you very much, and we look forward to representing you again next session.